Floor to Laima Šeputienė. She's Vice President for Criminal Cases of District Court of Kaunas Chamber. So Laima will join us via Zoom.
Labrit.
Labrit.
Good morning, dear guests. So my name is Laima Šeputienė. I'm just from District Court Kaunas Chamber. And I have been working with criminal cases for 10 years. And I'm glad to be a part of this project. It was very useful and interesting. And today, at the end of this project, I would like to represent the main aspects of judicial cooperation and Lithuanian practice. So, the mutual trust in each other's judicial systems expressed by member states of the European Union while implementing European Union mutual recognition instruments in criminal matters is the basis for an effective judicial cooperation among European Union member states. Such cooperation would not be possible without our regular mutual communications, consultations, active mutual cooperation, and goodwill in dealing with issues arising in judicial practice. Today, I am going to present the experience of Lithuania of implementing the two most important legal instruments in the area of mutual recognitions in criminal matters. These instruments are Framework Decision 909 and 947. For the purpose of ensuring implementation of the Council Framework Decision mentioned above, a special law was adopted in Lithuania on 13 November 2014 regarding the recognition and enforcement of judgments in criminal matters adopted by member states of the European Union, which entered into force on 1st April 2015. The law details the procedure and the terms for mutual recognition and enforcement of judgments by member states of the European Union imposing deprivation of liberty, non-custodial sentence and probation decisions, and forwarding identical judgments adopted by courts of the Republic of Lithuania for enforcement by other member states of the European Union. So before moving on to actions by Lithuania, it is important to stress that while acting in accordance with the Framework Decision 909, Lithuania has sent notification that the Ministry of Justice of the Republic of Lithuania is the competent authority to receive judgments on deprivation of liberty forwarded by member states of the European Union and to conduct consultations, whereas district courts are competent authorities for recognition of the judgments mentioned above and adopting decisions on deprivation of liberty for enforcement in another member states of the European Union. As of 1st July 2021, this year, these functions will be taken over by the Prison Department. Under Framework Decision 947, the district courts in Lithuania are competent authorities to receive directly and to recognize judgments forwarded by other member states of the European Union imposing non-custodial sentences and decision on probation, as well as to transmit the judgments and decisions which were just mentioned. The probation service is the competent authority for enforcement of judgments recognition by courts. Lithuania has also notified that it would recognize judgment issued by a competent authority of another member states of the European Union only if the certificate has been translated into Lithuania, as well as it may request that the decision or its essential parts are accompanied by a translation into the Lithuanian language. So the challenges faced by Lithuanian courts in their practice is that Lithuanian translations of documents, certificates, forwarded by some member states of the European Union are not always of high quality, especially in terms of appropriate legal terminology. In order to speed up the process, courts often send the documents received by to be retranslated by local translators instead of requesting a new translations from the issuing authority. So, a little bit our actions. Lithuania as the executing state by framework, I'm talking about framework decision 909. So upon receipt of a judgment from another member states of the European Union imposing deprivation of liberty and the certificate to this effect, the Ministry of Justice of the Republic of Lithuania forwards both documents within 5 working days to a district court having jurisdiction over the matter and submits to the court all information on the consultation, which took place on more favorable conditions for social rehabilitation of a sentenced person, also informs the sentenced person if he or she is within Lithuania. At court, this issue is deliberated not during a hearing, but under a written procedure, whereby the parties to the proceedings are being informed and offered a possibility to submit their replies. Having completed the written procedure, a copy of the decision is sent to the sentenced person, the defense lawyer, and the prosecutor on the next working day at the latest. The general time limit for holding the proceedings is 30 days from the date of receipt of the documents at court, except where the proceedings involve sending requests to the competent authorities or the other member states for additional information. Either way, the final judgment, including the time limits for appeals, will be adopted within 90 days at the latest. Once the decision becomes final, the court informs the competent authority of the other member states of the European Union within 5 working days at the latest. Moreover, within 3 days, it makes other arrangement necessary for the enforcement of a judgment imposing deprivation of liberty. The sentenced person is usually transferred within 30 days from the day of entry into force of the final sentence and at the latest. So, and we have a practical problem that competent authorities of some member states of the European Union apply to courts not via the Ministry of Justice, but directly, which results in a decisions being taken within a longer time limit as the courts are obligated to transmit the documents received to the Ministry of Justice first. As I have mentioned already, in the cases prescribed by the law before forwarding the documents received to the courts, the Ministry of Justice is obligated to consult with the competent authority of the requesting member states of the European Union. After the consultation, it shall evaluate more favorable conditions for social rehabilitation for the sentenced person, and only having agreed on these issues may forward the documents to the relevant district court having the territorial jurisdiction. So Lithuania as issuing state, the authority enforcing the sentence applies to court with a proposal to transfer a sentence imposing deprivation of liberty adopted in the Republic of Lithuania for enforcement to another member states of the European Union. At court, the proposal is deliberated under oral procedure. Parties to the proceedings are summoned to a court hearing. Once a judgment becomes final, the court transfers the judgment along with the certificate to the competent authority of another member states of the European Union within 3 working days at the latest. If a sentenced person is within the territory of the Republic of Lithuania, such person is also notified. Upon receipt of a notification for the competent authority of the other member states of the European Union that a judgment was adopted, information about this is given to a sentenced person, the authority enforcing the sentence, the Ministry of Justice of the Republic of Lithuania. If the sentenced person is present within the territory of the Republic of Lithuania, the Public Security Service and the Ministry of the Interior and the Lithuanian Criminal Bureau are informed as well. A sentenced person shall be handed over within 30 days from the date of entry into force of the decision to recognize the judgments. So, and practical problem we have that sometimes when courts are sending documents to the designated email address of the competent authorities of some member states of the European Union, documents are not delivered because the email system automatically blocks message from an unknown sender. In this case, courts are forced to send documents by regular mail, which prolongs the time of delivery. In addition, sometimes member states fail to respect the time limits for recognition and enforcement of judgments by courts of the Republic of Lithuania, which is why reminders have to be sent to such courts. So, and our actions following the implementation of the Framework Decision 947, so Lithuania as the executing state, so having received a judgment adopted by a competent authority of another member states of the European Union, imposing a non-custodial sentence or decision on probation and a certificate directly, a district court deliberates this issue under a written procedure without holding a hearing. The parties to the proceedings are informed of the time and date of the procedure and are offered the possibility to submit their replies. A reply by the probation service, by the way, is mandatory. Having deliberated the issue, a copy of the decision is sent to the sentenced person, his or her defense lawyer, and the prosecutor on the next working day at the latest. A total duration of judicial proceedings is 45 days from the date of receipt of the record at court, except where competent authorities of another member states of the European Union have been contacted by additional information. Otherwise, the final decision has to be adopted within 60 days from the date of receipt of the documents at court at the latest. If this time limit has been extended in exceptional cases, the competent authorities of the relevant member states of the European Union has to be informed thereof, indicating the reasons for delay and the expected time necessary for the adoption of the decision. Once the decision becomes final, the court is obligated to inform directly the competent authority of the relevant member states of the European Union within 5 working days at the latest. So, and the judgments is executed under the laws of the Republic of Lithuania. And Lithuania as the issuing state, so the probation service contacts the court requesting the latter to transfer to another member states of the European Union a judgment on a non-custodial sentence or on probation for enforcement by imposing an alternative sanction or probation measure in respect of a sentenced person. The court may also by its own motion solve the issue of transferring a judgment on a non-custodial sentence or probation for enforcement to another member states of the European Union. Such proposal is deliberated at a court under an oral procedure by summoning the parties to the proceedings. Once the decision enters into force, the court is obligated to forward the certificate along with the decision to a competent authority of the respective member state of the European Union within 3 working days. A court which has received a notification from a competent authority of another member state of the European Union that a decision was adopted to recognize and enforce a judgment on a non-custodial sentence or decision on probation shall inform about such notification the sentenced person if he is present in the Republic of Lithuania and the probation service, which shall immediately terminate the enforcement of an alternative sanction or probation measure. So, and we have a practical problem that probation service do not always collect and submit to courts information about the links of a sentenced person with another member state, for example, regarding the place of residence in another member state of the European Union, which results in a situation where, after sending a certificate with the judgments for enforcement, Lithuania is later forced to reclaim its right on enforcement of the judgments related to a non-custodial sentence or decision on probation. It has to revoke the previous ruling and the certificate. So a little bit statistic, 2019 in Lithuania. So 2019, under the Framework Decision 909, Lithuania received 57 requests, of which 38 were satisfied and 90 rejected, and we examined 9 requests and 5 were satisfied and 4 rejected. So under Framework Decision 947, we received 8 requests, of which 6 were satisfied, 2 were rejected, and we examined just 4 requests, and all 4 requests were satisfied. And at the end, the most frequent reasons for rejecting recognition and enforcement of judgments and decisions by competent authorities of other member states of the European Union in Lithuania are as follows. So the remaining duration of a sentence or a non-custodial sentence is shorter than 6 months. The decision made is related to a crime, not carrying criminal liability in Lithuania. If there are doubts as to whether the decision requested to be recognized is indeed final, if it transpires that a decision was made in absentia, if it has been determined that the conditions for enforcing the sentence are worse in Lithuania, lack of additional information, for instance, about the deportation procedure, missing information for another member states of the European Union, non-translation of the judgments, decision provided, and the least if the determinate place of residence of a sentenced person is not within the Republic of Lithuania, but in another member states of the European Union. So thank you for your attention. If you have a question, you can write in chat. So thank you very much.
Thank you. Thank you, Laima. Thank you, Anita. Thank you, Tanya. So if you have a question, you can free to ask via Zoom. And if you have a question what you would like to written down, so write it in a chat room, and the speakers are going to answer it there. So, vai kādam ir jautājums, kurš vēlas uzdot jautājumu?
Would anyone like to ask the question directly using the Zoom? Please. If I may, I would like to ask a question. Ilvars Turkapuls from the Ministry of Justice of the Republic of Latvia. Question to Lithuanian and Croatian colleagues about human rights aspects. How do you ensure human rights when you receive a request from other countries? So let me give you an example of what I mean. So we received certification from competent authority in another country. The convicted person was against it, and we also were notified by the prison administration that this person is infected with HIV and hepatitis C, and this convicted person was being prescribed a treatment in particular place of imprisonment. Unfortunately, the Latvian court disregarded this aspect. So my question to Croatian, Lithuanian colleagues, to what extent should we link the justification for rejecting the request with the human rights issues?
Laima, so, microphone. Oh, Tanya.
Yeah.
Okay. Yes, please.
So we don't question the procedure and the judgment from the foreign country. If this person has any appeals or anything concerning the procedure in that country, we say you use it in that country. So if we receive a judgment from Germany, and we say you use all the remedies and all your what you have to say about that procedure, you do it in front of the competent authority of Germany. If it is, that person is Croatian national and has a residence in Croatia, we always take the sentence and we bring a decision that this person will serve the sentence in Croatia. Once we bring such a decision, that decision is, how we say, Croatian judgment. And only from that point forward, this person can use all the remedies against this decision in Croatia, as from that point we consider it to be a judgment that's under the Croatian law. Everything that happened before that moment, this person should try to solve it under the, for example, German law. If I understood you clearly.
Yeah, Laima.
So first of all, we have a conduct consultation with another member state. It will be better in Lithuania the if social relations in Lithuania are stronger, then of course he will not come to Lithuania, so he will transfer to Lithuania. But first of all, we have a strong consultation, so with another member state.
Thank you, Laima.
So defense lawyer always is a point. So point.
Thank you. We have more questions. Mums ir vēl jautājumi. Lūdzu, dod.
We have more questions, and the floor is given to Jānis Baumans. Good afternoon, everyone. I'm the Supreme Court advisor, Jānis Baumanis. I wanted to ask a question about precedents, about ambiguous cases, probably, or more complex cases that are linked to double criminality. And in other words, offences punishable according to criminal code in both countries. Country that has convicted a person and country that needs to enforce this conviction. And I would like to talk about the qualifying features. For example, in Latvia, there's a difference whether there's an armed robbery and whether this armed robbery has been committed using a valid weapon. For example, in the United Kingdom, nobody checks whether this gun actually works, whether it can actually shoot. It's just a weapon, so it's an aggravating circumstance and a qualifying feature. So in our case, we have to nevertheless analyze the weapon, whether it can actually shoot, and then it can be qualified as a weapon that can be used in inflicting harm. Otherwise, we have to qualify it as a lesser crime with a lesser sentence. Do you have similar problem in Croatia and Lithuania?
Also for Tanya and Laima, so you can choose.
Thank you.
Yeah. Tanya, go first.
Thank you. We try to be pretty open for the double criminality check, and we do not go into details. So to say that the double criminality is not reached, it must really be something that we cannot put under any offense. We don't, if it is stated in the paragraph about the facts that the person used the gun, that's sufficient for us to say it was armed robbery. So we wouldn't check and ask, for example, the United Kingdom, but not anymore, but for example, as you gave example, we wouldn't ask them, did you check the weapon? Is it okay? Did he try to shoot, or was he able to, you see? So if you just put me in the facts that he had a gun, that's enough for me.
Thank you, Tanya. Laima, please.
I'm sorry, I couldn't hear the question. Can you quick repeat?
Okay, the question is an example. If in Latvia there is a law, when you're robbing the shop and you use gun, there is a difference. Is it like something looks like a gun, or is it a real gun in a shooting circumstances, so you can shoot with it? There is a difference between how many years you can get in this case. So, and an example, if in Lithuania you are getting an example from United Kingdom, the case where it's saying there was a gun, there was an armed robbery, are you going to check was this gun ready to use, or was it just moulage, or no?
Okay, I understood. Yeah. Okay, no, we will not check if this crime, and we just adapt the penalty. So we don't check the qualified. So qualification.
Okay, thank you, Ivars and Jānis. Thank you for your questions, and thank you, Inita, Laima, Tanya, for your presentations and answering the questions. So thank you very much. And